Morning. Am I audible?
Very good morning, sir. Yes, you are audible. And very good morning to all of you. I hope you all can see me and hear me. So, without any more delay, we can start the session now. So, today we have Professor Faizan Mustafa sir with us, and I can say this for a fact that he needs no introduction. We all know him pretty well. In fact, we often call him the most famous legal academician of the whole country. It is a great honor for us that he's taking today's class for us on the important topics for judiciary examination. And again, it is a great honor for us that he'll be taking classes for JudiSure. He'll be covering constitutional law, and that is his expertise. We all know. So the course will be starting from 4th of December, and if anybody is interested, they can go to the website www.judisure.com and they can check out the details from there, and then they can reach out. We have last few slots left. So, all right, then I think we can start with the session now. I'll ask Professor Faizan to start.
Thank you very much, Ashia, and thank you, JudiSure. I must apologize for this delay of 20 minutes since I am traveling and there was a bit of internet issue. So from the first floor, I shifted just now to the ground floor. And in fact, in last 1 year, I have been largely in travel. And that's why when the legal awareness web series videos are also not coming regularly. आप सबका अभिवादन है जुडिश्योर के इस नए बैच के पहले सेशन में छठ की मुबारकबाद आपको दूं और दीपावली की तो बिलेटेड ग्रीटिंग्स। बिहार में आपको जैसे मालूम है कि आजकल मैं हूं और छठ बिहार का सबसे बड़ा पर्व है और बड़ी श्रद्धा के साथ लोग पूजा अर्चना सूर्य की कर रहे हैं। तो बड़ा मैं समझता हूं ऑस्पिशियस डे है इस नए बैच के लिए कि हम आज जुडिश्योर के एक नए बैच के साथ बात करने जा रहे हैं। मैंने ये बात बहुत बार कही है कि इंडिया में जितने भी कॉम्पिटिटिव एग्जामिनेशंस हैं उन सारे कॉम्पिटिटिव एग्जामिनेशंस में सबसे आसान एग्जाम अगर कोई है तो वो जुडिशरी का है। I have said it many times that the easiest competitive examination in India is that of judicial services. Unlike the UPSC, it is a state level exam. Unlike UPSC and BPSC and RAS and UPPCS and provincial services exam of various states, where people from all disciplines appear, in the judicial services, you have a unique advantage that only law graduates alone can appear. And therefore, the exam has become extremely easy. You need not compete with IITians. You need not compete with the people who have done MBBS or MS. You need not compete people who have done MSc. So it's an exam where you will be just competing with your own peer group. And allow me to say that since the legal education in many colleges is not of a very high quality, the competition again becomes very easy, and many students from best of the national law universities prefer to go for corporates or some of them write civil services exam. So judicial services is not the preference of many people within NLUs, and therefore you are not competing with the very best. And since you are competing with people who are almost as good or as bad as you are, if you make sincere effort of 3 to 4 months, and this sincere effort will not be just 2-hour evening classes by the JudiSure, but let us say another 6 to 8 hours of your own work. So I will count if for next 4 months, you are willing to put in some 8 to 10 hours of work, you will definitely qualify some judicial service exam, be it of Uttar Pradesh or Bihar or Haryana or Delhi or Telangana or any other state. And therefore, you can start on an optimistic note that success in judicial services is almost assured to anyone who is willing to put in that kind of effort or willing to invest in his life for 4 months, just about 8 to 10 hours. हिंदी में बताता हूं कि क्योंकि राज्य के स्तर का एग्जाम है, सिर्फ लॉ जिन लोगों ने किया है वो इस एग्जाम को लिख सकते हैं, तो प्रतियोगिता उतनी कठिन नहीं है जैसी यूपीएससी की होगी या बीपीएससी की होगी या राजस्थान एडमिनिस्ट्रेटिव सर्विसेज की होगी। जो लोग ये इम्तिहान दे रहे होंगे वो आपकी तरह ही अच्छे या बुरे होंगे, इसलिए अगर 8 से 10 घंटे आप इसमें काम करने के लिए तैयार हैं, मुझे पूरा विश्वास है और मेरा जो एक बहुत लंबा तजर्बा जुडिशियल सर्विसेज को देखने का है एज पेपर सेटर या एज इंटरव्यूअर, उससे मैं ये कह सकता हूं कि कोई भी आदमी जो 3-4 महीने 8 से 10 घंटे इसकी तैयारी कर ले वो जज यकीनन बनेगा। तो एक उत्साह के साथ और एक पॉजिटिविटी के साथ आप इस अगले 3-4 महीने के कार्यक्रम को आज शुरू कर रहे हैं। जुडिश्योर, मैंने पहले भी कहा था और आज भी कह रहा हूं, कोई कमर्शियल वेंचर नहीं। जुडिश्योर इस चीज में इंटरेस्टेड नहीं है कि हम बहुत से बैचेस चलाएं, बहुत से पैसे कमाए जाएं इससे। आइडिया ये है कि थोड़ी हैंड होल्डिंग कर दी जाए। जो कुछ लॉ कॉलेजेस और लॉ स्कूल में पढ़ाया जाना चाहिए था वहां नहीं पढ़ाया गया, तो एक कैप्सूल फॉर्म में आपको एक्सपर्ट्स द्वारा वो चीजें जो 5 साल में पढ़ाई जानी चाहिए थी वो 3-4 महीने में पढ़ाई जाए। ये कोई आसान काम नहीं। किसी के पास भी कोई जादुई छड़ी नहीं और अलाउद्दीन का चिराग नहीं और तथास्तु कहने की शक्ति नहीं कि हमने ये कहा कि बस चलिए आज इंडियन पीनल कोड तथास्तु और आप सब के सब पूरी आईपीसी समझ गए। पूरी आईपीसी तो शायद मुझे भी नहीं आती हो। आइडिया ये है कि बेसिक कंसेप्ट्स की क्लैरिटी आ जाए। वो प्रश्न जो जुडिश्योर में जुडिशियल सर्विसेज में आने वाले हैं, जुडिश्योर चाहता है कि कम से कम उन टॉपिक्स पर और जिस तरह के प्रश्न आते हैं और जैसा लिखा जाना चाहिए वो आपको बता दिया जाए और सिखा दिया जाए। इसलिए जुडिश्योर का एफर्ट है कि इंडिविजुअल हैंड होल्डिंग की जाए, 1-to-1 सेशन किया जाए, मॉक टेस्ट लिए जाएं प्रीलिम्स के और मेंस के, और बताया जाए आपको कि कैसे लिखा जाए। मैं एक लॉ टीचर हूं और मेरा इंटरेस्ट ये है कि देश का लीगल सिस्टम इंप्रूव करे। बहुत साल पहले मैंने, जब जस्टिस काटजू ने एक जजमेंट में कहा था कि समथिंग इज रॉट of Allahabad High Court, the judge did not have a jurisdiction in this matter. Then Justice Kardju, as a judge of a Supreme Court, in the judgment has written that something is rotten in Allahabad, like Shakespeare has written that something is rotten in Denmark. And then he said that judges are corrupt and there is a uncle syndrome in Allahabad and they do not know law. Then I had written that whether they are corrupt, Justice Kardju must be knowing because he is from Allahabad, or CBI and other investigating agencies should know. But if judges do not know law, I had said it boldly, blame me. I had confessed that if Indian judges do not know law, I should be blamed because I am a law teacher. That means I did not teach them well. And from that day, this idea somewhere bothering me that not only I should try to teach well in the class, but I should also try to improve the judiciary at the district level. I don't believe it is right to call lower judiciary or subordinate judiciary. These are not the right terms. Whether you are a Supreme Court judge or you are a High Court judge, you are all equal. It is a question of jurisdiction. A Supreme Court judge has a different jurisdiction, you have a different jurisdiction, but every judge is equal. And therefore, this expression subordinate judiciary is basically a wrong expression. Can I contribute in helping people to enter judiciary with some kind of clarity of thought about law, clarity about the constitutional values? Many judges at the district level do not look at all at the constitution because they say we are not a constitutional court. I personally don't agree with such a thing because constitution is the supreme law of land. It has implications for everyone. In fact, yesterday I initiated a novel scheme of taking constitution to madaris. I went to a 100 years old madrasa in Azamgarh, in Sarai Mir, and told the ulama that the supreme law of land is the Constitution. No law, no rule can be superior to the Constitution. Many of them had wrong ideas about freedom of religion, that whatever is their freedom of religion, whatever their religion says, under freedom of religion, they are entitled to that. I think we have not invested enough in creating an enlightened citizenry which knows the Constitution and values of the Constitution. We have wasted some 75 years in not preparing our country for the liberal, modern, progressive constitutional democracy. We just imposed it from the top and thought elections are good enough to sustain a democracy. 75 years down the lane, we know that we have not imbibed the constitutional values. Elections are more like a festival. Once in 5 years, we go and cast our vote without looking at the election manifesto, without looking at the policies of the different parties. And we vote in the name of religion. We vote in the name of a region. We vote in the name of a caste. The whole nation is to be prepared for a journey into a constitutional democracy. That we didn't do. And if our judges do not imbibe those things, then I think we are doing a great disservice to our legal system. There is a reason that for every judicial services exam, there are questions on the Constitution. Your interview will be largely on the Constitution. Some questions will definitely come from criminal law and procedural laws. Particularly those who are writing the exam in 2025, 2024, when the whole criminal law is being revamped. As many of you must have read that I was one of the 2 academicians who were invited by the parliament to present my views before the select committee which was examining the new penal code, new evidence law, new code of criminal procedure, which is now called the Nagrik Suraksha Adhiniyam. And for an hour and a half, I presented my views on the 3 bills. No interview will be conducted in next 2 years without asking a question on these 3 bills, which I hope in a matter of 3 weeks are likely to become the act, because with the massive majority available to the government, they will be able to pass these laws in the winter session, which starts on 4th of December. And I have made my views absolutely clear that while I had welcomed the initiative of reforms in criminal law, my expectations have not been fully fulfilled. I am little disappointed. I wanted more reforms to happen. In the evidence law, there is hardly any change. In the penal code, the reforms are much below our expectations. In the Code of Criminal Procedure, some very positive reforms have been made. There are few areas of concern which I inform the Parliament, but because the parliamentary privileges prohibit me from exactly telling you what I said in the Parliament, that's why I even refused to write an article after my appearance before the Parliament. So I'll not give you the details of all that, but broadly we can talk of the three bills and what are the positives and what are the negatives in these bills. But that is story for some other day. Today, let me confine myself to the most fundamental issues of Constitution. Just one thing, there is some disturbance. So some of the most fundamental ideas of the Constitution, if we develop clarity about them, then even when you are writing judgments, you would be able to make use of them because you know the whole purpose of a Constitution. We spend a lot of time on the salient features of the Constitution. Various provisions, fundamental rights, directive principles, separation of powers, federalism, precedent. But the most fundamental feature of a Constitution, which incorporates the purpose of the Constitution, unfortunately is not taught in most law colleges. And there is no reference to that idea even in the most books on constitutional law. I'm talking of idea of constitutionalism. Constitution and constitutionalism are not one and same. If you think constitution means constitutionalism, that means you do not have clarity on the subject. Constitution and constitutionalism are two distinct ideas, two distinct things. You may have a constitution and not have constitutionalism. There are constitutions which are not incorporating the idea of constitutionalism. Hitler had a constitution. Nazi Germany did have a Weimar constitution, but it did not have constitutionalism. Saddam Hussein, Colonel Gaddafi, China, Cuba, East Germany, many Muslim countries have constitutions, but they don't have constitutionalism. And therefore, constitution is not the ultimate step. It is the first step. The ultimate step is constitutionalism. संविधान का होना अपने आप में जीत नहीं है. संविधान का होना अल्टीमेट गोल और एम नहीं है किसी समाज का. संविधानवाद होना. संविधान हो सकता है और उस संविधान में संविधानवाद ना हो. हिटलर के पास भी एक संविधान था, वायमार संविधान, लेकिन संविधानवाद नहीं. सद्दाम हुसैन के पास, कर्नल गद्दाफी के पास, चाइना के पास आज भी संविधान है, संविधानवाद नहीं. कम्युनिस्ट देशों के पास, इस्लामिक देशों के पास संविधान है, संविधानवाद नहीं था. कम्युनिस्ट देश तो ज्यादातर समाप्त हो गए, मुस्लिम देश बाकी हैं, लेकिन उन देशों में संविधान है, संविधानवाद नहीं. क्या है ये संविधानवाद? What is this whole idea of constitutionalism? The idea of constitutionalism is the idea of limited government. Control on government, restrictions on the powers of the government, limitations on the powers of the government is the essence of constitutionalism. The government must have all powers which are necessary to govern. It will have the power to legislate. It will have power to execute. Judges appointed by the government will have the power to adjudicate. Whatever laws and orders government pass and issue, we are bound to obey them. But simultaneously, while we have empowered the government through the social contract theory, as Hobbes will say that in a state of nature, man was nasty, selfish, brutish, short. There was a danger to his life from the wild animals and from the fellow human beings. Human beings are wilder than animals. And the humanity and the men went to the person who was most competent amongst them. And they said, we will obey whatever you say. You become our king. And this is how the state came into being. What is said to be the social contract theory of origin of state. राज्य की उत्पत्ति का सामाजिक संविधा का सिद्धांत जो हॉब्स, लॉक और रूसो ने दिया कि आदि मानव नास्टी था, ब्रिटिश था, सेल्फिश था, उसके जीवन को खतरा था जंगली जानवरों से और इंसानों से जो जंगली जानवरों से भी ज्यादा खतरनाक. उसने जाके अपने जीवन की रक्षा के लिए और अपनी जायदाद की रक्षा के लिए उस व्यक्ति से जो उनमें सबसे योग्य था कहा, आप हमारे राजा बन जाओ, जो कुछ आप कहोगे हम मानेंगे। हम आपकी प्रजा बन जाते हैं, लेकिन हमारे जीवन की रक्षा हो, हमारी प्रॉपर्टी की रक्षा हो। तो राज्य की उत्पत्ति किसी दैवीय सिद्धांत से नहीं, किसी शक्ति के प्रयोग से नहीं, बल्कि लोगों की स्वेच्छा से, अपनी इच्छा से, एक संविदा के तहत, एक कॉन्ट्रैक्ट के तहत हुई। एक मुआहदा हो गया, एक एग्रीमेंट हो गया, एक पवित्र संबंध बन गया, जिसको आपने सोशल कॉन्ट्रैक्ट कहा और जिसे आज संविधान कहा जा सकता। यानी संविधान राज्य और लोगों के बीच जो एग्रीमेंट है, जो समझौता है, उस समझौते को दर्शा। राज्य के क्या क्या दायित्व होंगे वो संविधान बताएगा, लोगों के क्या क्या अधिकार होंगे वो संविधान दर्शाएगा। संविधान अपने आप में अधिकार देता नहीं, अधिकार तो हर मानव पैदा होने के समय से कुछ अधिकारों का हकदार बन जाता। फंडामेंटल राइट्स आर नॉट गिवन बाय द कॉन्स्टिट्यूशन। 1905 में बाल गंगाधर तिलक कह रहे हैं स्वराज इज माई बर्थ राइट। अभी कोई संविधान नहीं बना है, अभी राइट ऑफ सेल्फ डिटर्मिनेशन नहीं आया है। कोई भी इंसान हो, कितना भी बुरा इंसान, कुछ बेसिक मौलिक अधिकार, नेचुरल राइट्स, बेसिक राइट्स, फंडामेंटल राइट्स का उसको अधिकार हो। तो सोशल कॉन्ट्रैक्ट का जो आइडिया है, उस आइडिया को मॉडर्न जमाने में संविधान ने इनकॉर्पोरेट कर लिया। प्रजा और राजा के बीच एक कॉन्ट्रैक्ट हो। इसलिए प्रजा को पता होना चाहिए संविधान क्या है, और राजा को भी पता होना चाहिए संविधान। इसलिए मैं पूरे देश को संविधान पढ़ाना चाहता हूं, ताकि सारा देश संविधान की मर्यादाओं और संविधान के मूल्यों को अपने जीवन में उतार। अब ये जो एक आइडिया कॉन्स्टिट्यूशनलिज्म का है, इस आइडिया का अर्थ थोड़ा और गहराई में जाएं तो क्या है? We empowered the state, gave it all the powers which were necessary for it to govern us. At the same time, we are conscious of the fact that power corrupts and absolute power corrupts absolute. And since power corrupts and absolute power corrupts absolutely, absolute power is not to be given to. Therefore, this becomes the fundamental idea of constitutionalism. No one will be supreme. Parliament is not supreme. Supreme Court is not supreme. I have written in number of articles, Supreme Court should not take its name and nomenclature seriously. It is not supreme. It is to hear appeal from the High Court. That's why it is supreme. But it is not superior to Constitution. Supreme Court is also under the Constitution. Parliament is also under the Constitution. President and Prime Minister and Cabinet Ministers and Vice Chancellors and District Collectors and Chief Ministers and Governors, everybody is under the Constitution. Recently, Supreme Court said about Punjab governor. The governor does not have the power to question the convening of the assembly. Governors cannot forever sit on the bills passed by the assembly. So nobody is above the Constitution and everybody is under the Constitution. Many people believe that their religion is above the Constitution. And they are not bound by the Constitution's right to equality and gender justice. This was the theme of my lecture yesterday in a 100-year-old madrasa, that this is a wrong idea. You are bound by the Constitution. Everybody is bound by the Constitution. All laws, all orders, all philosophies, they are subordinate to the Constitution. And therefore, constitutionalism, as I said, Nilesh wants the AI summary. The human summary is better than AI summary. Constitutionalism is the idea of limited government, I have said earlier. Now I am saying it is an exercise on the restraint on power, limitations on power. क्या है संविधानवाद का आइडिया? राज्य की शक्तियों पर अंकुश का नाम संविधानवाद है. राजा को भगवान की तरह की अनलिमिटेड शक्तियां नहीं. अगर भगवान में विश्वास है तो ऑल माइटी भगवान होगा, लेकिन राजा नहीं. राजा की शक्तियों को सीमित किए जाने का नाम संविधानवाद. राज्य की शक्तियों को सीमित किए जाने का नाम संविधानवाद. न संसद संविधान के ऊपर होगी, न सुप्रीम कोर्ट संविधान के ऊपर होगी, न राष्ट्रपति संविधान के ऊपर होगा, बल्कि सब के सब संविधान के अधीन होंगे और संविधान के अंडर. संविधान सबसे बड़ा हो. हर एक की शक्तियां उतनी ही होंगी जितनी संविधान देगा. हर एक के लिए एक लक्ष्मण रेखा खींची जाने का नाम संविधानवाद। हर एक सीमित दायरे में ऑपरेट करे। संविधानवाद का सिद्धांत ये है, अपनी लक्ष्मण रेखा मत क्रॉस करो। लक्ष्मण रेखा सिर्फ सीता की ना होगी, बल्कि हम सब की। कोई लक्ष्मण रेखा ना क्रॉस करे। इसलिए सेपरेशन ऑफ पावर्स का आइडिया संविधानवाद का आइडिया है कि शक्तियों का विभाजन कर दिया जाए। जब कार्यपालिका, न्यायपालिका और विधायिका में शक्तियां विभाजित हों तो उसको सेपरेशन ऑफ पावर्स कहा जाता है। जब राज्य सरकारों और केंद्र सरकार के बीच शक्तियों का विभाजन हो, उसको डिस्ट्रीब्यूशन ऑफ पावर्स कहा जाता है। रूल ऑफ लॉ का आइडिया क्या है? संविधानवाद का आइडिया है कि किसी इंसान का, किसी व्यक्ति का रूल नहीं होगा, बल्कि कानून की सत्ता होगी। व्हाट इज रूल ऑफ लॉ? नो मैन विल रूल, everyone will be subordinated to law. We are governed by God and law. Everyone has to go by law. There is a difference between rule of law and rule by law. अगर आपकी संसद में और विधायिका में मेजॉरिटी है, आप कोई भी लॉ पास कर लें, अगर वो लॉ संवैधानिक मूल्यों पर पूरा नहीं उतरता तो वो रूल बाय लॉ है, वो रूल ऑफ लॉ नहीं है। कानून पास कर अपनी शक्तियों को बढ़ाना रूल बाय लॉ है, रूल ऑफ लॉ नहीं। संविधानवाद का आइडिया रूल ऑफ लॉ है, रूल बाय लॉ नहीं। इक्वालिटी का अधिकार रूल ऑफ लॉ का हिस्सा है। हर एक के लिए कानून बराबर होगा, कानून की नजर में हर एक बराबर होगा, हर एक को कानून का बराबर संरक्षण दिया जाएगा। इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉज ब्रिटिश रूल ऑफ लॉ से भी बोरो किया, अमेरिकन कॉन्स्टिट्यूशन के 14वें अमेंडमेंट से भी बोरो किया। तब भारत का अनुच्छेद 14 बना। जितने भी मौलिक अधिकार हैं उनका कार्य क्या है? संविधानवाद। हर मौलिक अधिकार का पर्पस एक है, राज्य की शक्तियों पर अंकुश। जब मुझे धर्म की स्वतंत्रता है, इसका मतलब राज्य को मेरे धर्म में हस्तक्षेप करने का हक नहीं। मैंने मदरसे में जाके बताया कि इसका मतलब ये नहीं कि जो कुछ आपका धर्म कहता है वो देश का कानून परमिट करता है। इस कानून को और पढ़ो, इसमें देखो क्या इसमें पेचीदगियां हैं। अगर आपका धर्म और संविधान टकरा रहे हैं, धर्म को रास्ता संविधान के लिए छोड़ना पड़े। राज्य को मैं ये बताता हूं कि धर्म के मामले में क्योंकि संविधान ने एक ऑटोनॉमी दी है, एक स्वायत्ता दी है लोगों को, तो लोगों के धार्मिक मामलात में बहुत केयरफुली इंटरफेयर करना चाहिए और बहुत कम से कम करना चाहिए। समानता का अधिकार, राज्य की शक्तियों पर अंकुश, राज्य मनमानी नहीं कर सकता। राज्य किसी के फेवर में और किसी के अगेंस्ट नहीं हो सकता। राज्य ये नहीं कह सकता कि हम अपनी पार्टी वालों को सारी पोजीशंस दे देंगे। राज्य ये शर्त नहीं लगा सकता कि जुडिशियल सर्विसेज में सिर्फ वही आएगा जो हमारी पार्टी का मेंबर, नहीं। समानता के अधिकार ने राज्य से डिस्क्रिमिनेट करने की पावर छीन ली, ये संविधानवाद है। अब राज्य अगर चाहे कि इसको प्रिफर कर दूं, इसके विरुद्ध हो जाऊं, मुमकिन नहीं। राइट इक्वालिटी basically takes away from the state the right to discriminate. Freedom of religion takes away from the state the right to interfere in the purely religious matters of citizens. Even though freedom of religion in India is wide enough to include even non-citizens. Right to life and personal liberty is a big restriction, huge restriction on the power of the state. It cannot take away any life arbitrarily. Right against arbitrariness as a part of Article 14 is the biggest restriction on the power of the state and is a facet of constitutionalism. You cannot take away my life. You cannot curtail my liberty. Freedom of speech takes away from the state the power to impose censorship. Therefore, the whole idea of constitutionalism is what? Restrictions, limitations, restraints on the power of the state. The mechanism used to restrain and limit: separation of powers, distribution of power, rule of law, judicial review, fundamental rights, rule of law. Federalism is an idea to limit the power of the center. The whole idea is power is dangerous. ये 15,000 वॉट का जो हाई टेंशन वायर है, इसको छूना मत, भस्म हो जाओ। इसलिए उस पावर को डिस्ट्रीब्यूट करते हैं, सब स्टेशन बनाए, ट्रांसफार्मर बनाए, वो 15,000 को डिस्ट्रीब्यूट कर करके जब 220 वॉट में लाए तो बिजली जल गई और पंखा चल गया। इलेक्ट्रिसिटी का हाई टेंशन वायर के एग्जाम्पल को देखें, पावर सब स्टेशन पे क्या लिखा है? डेंजर साइन, खतरनाक। जब तक बिजली को डिस्ट्रीब्यूट ना किया जाए, 15,000 से 220 पे न लाया जाए, तब तक वो काम की नहीं है। इसलिए बिजली को जैसे डिस्ट्रीब्यूट करो, एक जगह पे हाई टेंशन वायर न रखो, उसी तरह शक्तियों का विभाजन, किसी को भी पूरी शक्तियां ना दो। इंसान है, कोई भगवान नहीं है। हर इंसान अपनी शक्तियों का दुरुपयोग कर सकता है। उस दुरुपयोग की संभावना को जितना कम से कम कर सकते हैं, उसको करने का नाम संविधानवाद है। इस सब के बावजूद भी दुरुपयोग होता है। जजेस अपनी जुडिशियल पावर का दुरुपयोग करते हैं और जुडिशियल एक्टिविज्म करते हैं, जुडिशियल एडवेंचरिज्म करते हैं। पॉलिसी मेकिंग जजेस का बिजनेस नहीं है, लेकिन पॉलिसी मेकिंग में बोलते हैं। ब्रूट मेजॉरिटी पार्लियामेंट में संख्या बल पर अक्सर ऐसे कानून पूरे विश्व में बनाती रही है जो कानून संविधानवाद के विरुद्ध है। संविधानवाद का पूरा आइडिया ये है कि कोई अपनी शक्तियों का दुरुपयोग ना करे, हर एक की शक्ति सीमित हो। द होल आइडिया ऑफ कॉन्स्टिट्यूशनलिज्म इज नो वन शुड बिकम एब्सोल्यूट रूलर, नो वन शुड हैव एब्सोल्यूट पावर्स, everybody's power must be restricted, must be limited. Since state has all the power, the military power, the police power, the intelligence power, CBI, ED, this and that. Article 13, Article 12 talk of what? State. The fundamental rights chapter starts with the definition of state in Article 12. Because the greatest threat and the biggest threat to fundamental rights comes from the state. State is in the best position to violate rights. And therefore, state is the primary addressee of fundamental rights chapter. State shall not discriminate. Article 15 will say only on grounds of religion, race, caste, sex, place of birth. Everyone shall have equality of opportunity. It is a limitation on the power of the state. And every state would be unhappy with fundamental rights. Naturally. If you try to limit my power as a vice chancellor, I will not be happy. I would like to increase my power as a vice chancellor. I can do whatever I want. This is what I would like to do. And that is why many vice chancellors end up as totalitarian and authoritarian rulers. And then students protest against, teachers protest against. non-teaching staff protest against. This happens because they have not inculcated constitutional values. They think that they have really become God. For the preparation of judicial services, I would very strongly suggest that you master your bare act, you master your basic concepts. Your conceptual clarity is key to success for any exam, but particularly in judicial service. You must be clear about the ingredients of various offenses. You must know the leading cases on that subject. You should be able to distinguish one idea with another. It is said about the selection of judges, I mean the superior court judges. While selecting a judge, find a good man. If he knows little bit of law, it is icing on the cake, because judges are having the benefit of arguments by the lawyers. Lawyers will tell them the law. But how will they understand which lawyer is telling the correct law? Because lawyers take sides. They will try to twist the law, interpret the law in favor of their client. The other party will use the same law in favor of his client or her client. You as a judge, if you have conceptual clarity, will be able to adjudicate fairly as per the letter of law and as per the spirit of law and as per the mandate of the Constitution. If you have any questions for today, I can take. This is a preliminary class, so I'm not taking you to all the intricate details. If there are any questions, I am willing to take. You can write your questions. If the host has kept you mute, just write the questions, I will answer. Rizwan, for the purposes of your interview, you should be very careful in asking and answering a political question. So you must always remain within the confines of this exam. And therefore, if this question is put, you should say that every government is supposed to follow the ideals of constitutionalism, and most governments try not to follow constitutionalism in totality, because no government has ever been perfect. We are not ruled by angels, we are ruled by human beings, and human beings are human beings. Human beings have all the human weaknesses. And that's why there has not been any government which fully meets the yardstick of following constitutionalism. Yeah, Shivam, to develop a judicial mind, you must look at things objectively. So don't bring your ideology, don't bring your politics, don't bring your religion. Stay on law. If you stay on law and the purpose of law, you would be able to adjudicate fairly, honestly, and in a manner that nobody can object to that. A judicial mind means that you look at things absolutely in a detached manner. You are not supposed to be a referee of a football match. Be an umpire of a cricket match. Shubham, you cannot talk of constitutionalism either in monarchy or in autocracy. And therefore, democracy, I would say, is definitely sine qua non for any idea of constitutionalism. First of all, you need to have democracy. Then only the question will arise whether your democracy is good enough to incorporate and propagate the idea of constitutionalism. So, in the evidence law, Uma, my expectation, for instance, was just to give one example that how can you have this idea of conclusive proof? If you look at the definition of conclusive proof, it says if one fact is proved, the other shall be the conclusive proof of that fact. I think this is too far-fetched. The imperial code drafted by the British could have incorporated such an absurd provision. A modern code should not have this kind of provision. Similarly, I think we have not really improved on the whole idea of relevancy and admissibility of evidence. We have not incorporated, for instance, the hostile witness rules, and we have not incorporated, sorry, not the hostile witness, we have not incorporated the witness protection scheme. We have left it to the state governments. In a number of high-profile cases, the witnesses have turned hostile because they are fearful and scared. So I had expected that the new Evidence Act would have a very detailed scheme of witness protection, which unfortunately is not there. Yeah, Vikrant is right. हमको first principles पर focus करना चाहिए. Definitely. Yeah, 1 minute. Let me. I've got many questions, so I will briefly answer them. Yes, one. Gaurav, idea of constitutionalism is dynamic, but the fundamental core is well established that if you have a limited government, then you are following constitutionalism. Samira, I will not say much on nomenclature, but translating procedure into suraksha is problematic. Because in Article 21, we have no one shall be deprived of his life or liberty except according to the procedure established by law. So since there we have translated procedure as prakriya, how can criminal procedure be called suraksha? It is difficult. And I can't give you all the details of what I said, but nomenclatures are little problematic because the names as per the constitution, the way the constitution exists today, have to be in English. Yeah, new criminal laws, Anarjan, will definitely be implemented immediately, and the legal system will get ready. The moment President of India signs them, then the old IPC, CRPC evidence will not remain, laws on the statute book. Yes, Maharashtra वाला Delhi Judicial Services का एग्जाम दे सकते. Sahil, if you have just 2 hours for a day, then 4 months will not be enough for you. Then you have to prepare for 7-8 months. The older acts, good question by Amrita Grover. You should start preparing with the older acts because in substance, not much is changing except the number of sections. So it is okay if you start with the older acts. Say the definition of murder, culpable homicide remains the same. Only from section 300, it will become section 100. So it will take time for us. For me, it is very difficult to change the number in my mind, but we have to live with this reality. But for the purposes of preparation, I think the principles remain the same. The cases will remain the same. Therefore, you should continue with old. Gopeshwari, this is the whole difficult question whether personal laws are laws or not. If you go by the Narsu Appu Malli judgment of Justice Gajind Gatkar and Chagla, personal laws are not laws. But I am inclined to believe that this judgment will soon be overruled and personal laws will be held to be laws and therefore bound by the mandate of fundamental rights. Yeah, it is possible, Dheeraj, that you have constitutionalism and you do not have a constitution in a narrower sense, that there is one document which is called constitution. England does not have a constitution like this, but they have constitutionalism. Israel does not have a constitution in the narrower sense. So it is possible that you have constitutionalism without having constitution as one book. Mariam, I would say that for judicial services, you can pick up this VN Shukla or MP Jain for the purposes of judicial services. I think, Vikrant, this 70% rule has been withdrawn. That people who have scored 70% marks, they can alone write the MP Judicial Services exam. As far as I know, the rule has been withdrawn. Harshvardhan, that's very good. If you are a first-year GNLU student at the new Silvassa campus, which I have not yet visited, if you start preparing from now on, then for you, even 2 hours other than the judicial. Yes, Muhammad, the checks and balances on legislature, judiciary, and executive are nothing but idea of constitutionalism. Yes, Supreme Court, Ms. Kumari has already said it, that the governors cannot forever sleep over the bills because it violates the spirit of constitutionalism, of course. If you are starting from crash, Shruti, I think 4 months are good enough if you are willing to put in 8 hours a day. Sahib Alam, I can't teach you UCC and everything in one class. This is an introductory class. I would need a separate class to talk about advantages and disadvantages of UCC. But of course, there will be a day during this course when I will talk to you on UCC. Yeah, there was a need to change CRPC, IPC, CPC, etc. But the changes are not as many as we expected. Umar ji, if you are preparing to become an assistant professor in National Law School, Bangalore, that means you have already done LLM. Get your basics right, because Sudhir Krishna Swami, who is a vice chancellor, is a hard taskmaster, and you will have an excellent interview panel to interview you. So prepare on your LLM dissertation, on your PhD topic, and again, even for assistant professors interview, we basically look for conceptual clarity. Loriki, I don't think many opportunities are available with LLM IPR. There is an oversupply and less demand. IPR is not even a compulsory subject as per Bar Council of India. Many universities do not have IPR as a subject, and in those who are having it already, people have been appointed. So if you are interested to prepare for judicial services, IPR will not be of much help. Criminal law can be of great help for you. Sahib Alam, I have already answered your question. Don't put it in. I am not a great votary of morality of constitution idea, Khalik, because the provisions of the constitution are good enough. And the spirit of the constitution and the morality of the constitution can be deduced from the preamble of the constitution. But lately, the judges have been talking about constitutional morality and enhancing their powers. I am not a great votary of it. Saib Alam, please don't repeat the question. I have already answered. Vaishnavi, good question, but it requires a little bit of a discussion. Legally speaking, the people of India are sovereign, but in the ultimate analysis, it is the Parliament of India which exercises the sovereign legislative power. Anushka, this 70% rule of MP has been withdrawn as far as I know. Jai Shankar, if you want clarity of concepts, which is necessary for practicing, then you should join JudiSure. I have already said, Mariam, that you can pick MP Jain or VN Shukla for constitution. Populism, Kenny, is not the same as constitutionalism. In fact, the majority opinion and constitutionalism may be two different things. Constitution is supreme, not the people, because ultimately people have agreed to be governed by the constitution. So you cannot say just because the majority wants that right to equality should be removed, it should be removed. This cannot be done. Nitesh, don't be confused. Go slowly. First you qualify the prelims and then prepare for the mains. We have combined in this curriculum for JudiSure, and this curriculum will take care of both for your prelims and mains. Ranjit, you can read my article on the three bills. You are not supposed to memorize everything, but there are things for judicial services, Sarika, which you need to memorize. There are ways to memorize. If you develop interest, you will be able to memorize them easily. अभी आप ओल्ड एक्ट पढ़िए, फिर अफजाल न्यू एक्ट आ जाएगा तो उसके बाद न्यू एक्ट पढ़ा जाएगा, कोई ज्यादा फर्क नहीं है दोनों. Shamim, you will develop the good judgment writing skill by writing more. निर्मल, it is a very basic question. NLU से LLM करें या कहीं से भी, अगर आपने क्रिमिनल लॉ में अच्छा LLM किया है तो आपको लिटिगेशन में हेल्प मिलेगी. Pulkit, I have already spoken on the governor and cited the Supreme Court judgment in Punjab that takes care of even Tamil Nadu government. Don't go, Ananya, by these words, constitutional jurisprudence. They don't mean much. The theory of constitution is constitutional jurisprudence. It is not necessary to do LLM, Mariam, before giving judiciary. Most of the judges qualify after doing their LLM. Ranjit, Kinka constitution padhte, I really don't know, but I largely read the articles and judgments. I don't read the books. Pradeep, it is difficult to say constitutionalism lies in the positive school or the philosophical school. Constitution definitely does not lie in the positive school. Constitution, basically, in terms of principles, if you say, would be following higher principles, and therefore would be closer to the natural law school. So basically, it combines number of schools. Yeah, Sudhir is Aditya. Sudhir is the vice chancellor in Bangalore. Nirmal, I have already spoken about criminal law. So I think I have answered almost all the questions. Arshia, I leave?
Yes, sir. Thank you so much for this amazing session.
Okay, thank you very much.
It was
Okay. All the
an
best.
honor to host you today, and we will look forward to host you again for the class soon. Thank you, sir.
All right.
And
Okay.
thanks everyone
Bye-bye.
for joining. You all may
Bye.
leave the session now.